Upon assumption of office as the Attorney General and Minister of Justice, I have taken certain decisions on prosecutions that were instituted by my predecessors. That is the Honourable Gloria Akufu and the Honourable Godfrey Yeboah Dame. Specifically, I decided to drop the criminal charges laid against certain government officials who served in the NDC government that left office in January 2017. My fellow citizens, I did so mindful of the fact that I am serving in a government that came to power on the back of promises of exacting accountability from everyone who has served or is serving in public office. I am here today to account to my fellow citizens for the decisions that I have taken so far. As your Attorney General, I am keenly aware of the fact that the prosecutorial authority vested in me under Article 88 of the Constitution is discretionary in nature and is subject to the constitutional requirements set out in Article 296 of the Constitution. The import of these constitutional requirements is that in the exercise of my prosecutorial authority, I must not only act reasonably and fairly, but I must comply with all the requirements imposed upon me by law. I must also be candid with those whose life and liberty depend on my decisions. In addition, the Constitution requires that my decision to prosecute should not be capricious, biased, whether in resentment, prejudice, or personal dislike. Before taking any of the decisions I am about to explain, I consulted widely. One, I had several briefings from the Director of Public Prosecutions, that is the DPP, on each of the cases. Where I disagreed with her, I made my disagreement known to her with reasons. Two, I spoke to the defense lawyers in each of the cases, and again, where there were disagreements, as for instance in the banking cleanup cases, which I shall deal with shortly, I made my views known to the lawyers. Three, I spoke to some of the investigators involved in the cases at hand to get a sense of what they found during the investigation of the cases. And finally, I met with and discussed the banking sector cases with at least one of the receivers involved in those cases. I have scheduled a meeting with the second receiver, which is yet to take place. Ladies and gentlemen of the media, my fellow countrymen and women, the traditional view within the legal profession has always been that the Attorney General owes nobody an explanation for his decision to enter a nolle prosequi, which is Latin for there shall be no prosecution, or terminate a prosecution. But that view does not comport with the architecture of our Constitution, and I absolutely disagree with it. As ably articulated by Puaman JSC in his concurring opinion in Gregory Afoko versus Attorney General, which is suit number J1/8/2019, Supreme Court dated 19 June 2019 at page 20, and I quote, "The decisions to prosecute and to terminate prosecution of suspected offenders is a matter of immense public interest. Furthermore, it affects the rights of the suspected offenders who may be compelled to suffer the indignation of prosecution when there is absolutely no point in mounting prosecution on the facts of the case. It is because of these considerations that the modern trend in democracies is for prosecutorial authorities to be open about the factors on which they take the decisions to initiate or terminate prosecutions." End of quote. Therefore, my decision to be open and transparent about the factors animating the entry of nolle prosequi in some cases and the withdrawal of others is not only because I want to avoid accusations of partiality and or capitulation to political pressure, but also to comply with the constitutional requirements stated in Article 296 of the Constitution. More so, in the best ethics of the legal profession, every lawyer is mandated to act in the best interest of his client, and no lawyer worth his or her salt, will purport to act in the best interest of the client by doing so on the blind side of the client. As Attorney General, my only client is the Republic of Ghana, represented by its sovereign people. And as stated above, I intend to provide the reasons for my decisions in the cases in which I have either entered a nolle prosequi or withdrawn the charges laid against the accused persons. And I do so to my fellow citizens who have entrusted the power to me through the President of the Republic. Before I proceed to assign the reasons for my decision in each of the cases, I wish to crave your indulgence to provide a brief explanation of the technical difference between the entry of a nolle prosequi and the withdrawal of charges. The power to enter a nolle prosequi is contained in Section 54 of the Criminal and Other Offences Procedure Act 1960, Act 30. Pursuant to this provision, the Attorney General may enter a nolle prosequi at any stage of a criminal trial. The statute does not itself require the Attorney General to provide any reasons for his decision to enter a nolle prosequi in any proceedings. However, as I have made clear above, the constitutional principles in Article 296 impose an obligation on the Attorney General to be candid in the exercise of his discretionary power. And I cannot fathom how one can be candid without explaining one's actions. When a nolle prosequi is used by the Attorney General to terminate proceedings in a criminal trial, he reserves the right to bring fresh charges against the accused persons in the future. In contrast, the Attorney General may terminate criminal proceedings by withdrawing the charges against an accused person pursuant to Section 59 of the Criminal and Other Offences Procedure Act 1960, Act 30. Where the charges are withdrawn after the prosecution has closed its case, then the legal effect of the withdrawal is that the accused is deemed to have been acquitted and discharged. In other words, that accused cannot be brought back and tried on the same facts or for the same offenses. So in all the cases in which I have withdrawn the charges against the accused persons and in which the prosecution has closed its case, those accused persons are considered to have been acquitted and discharged. Ladies and gentlemen of the media and fellow citizens, my decision to terminate the criminal trial was animated in the main by three factors. The first was that for ethical and professional reasons, I could not in good conscience continue to prosecute some of the cases. The second was that for some of the cases, my own review and analysis of the charges showed clearly that the charges were defective, and some were filed against the promptings of plain common sense. The third was that in some of the cases, the evidence led so far that showed that there was a reasonable doubt as to the guilt of the accused persons, and no prosecutor should continue to pursue a case in the face of overwhelming doubt regarding the guilt of the accused person. Also, it is important to highlight the fact that in most of the cases in which I have terminated proceedings, the conduct of some of the individual judges left so much to be desired. I will deal with the issue of judicial conduct in my concluding remarks. Suffice it to say that it raises a specter of lack of fairness in criminal proceedings where a judge is seen to be overly hostile to the accused and unreservedly differential to the prosecution. Now to my first substantive reason for dropping charges in some of the cases. As I have noted above, for purely ethical and professional reasons, I could not in good conscience continue to exercise my prosecutorial authority under Article 88, Clause 3 in some of the cases. These cases were the Republic versus Kesiel Atoforsen and another, and the Republic versus Ofosu Ampofo and another. This is because I was deeply involved as counsel in these two cases. In the case of Republic vs. Atufosin, I was not counsel on record, but my junior partner, Godwin Kujo Tamaklo, also known as Eduji, was a counsel on record. As a team, we discussed our strategy in chambers, and I was involved in reviewing legal arguments and in some instances, authoring some of the arguments that we filed in court. I believed then, and still believe now, that the Honourable Atufosin was a victim of a political witch hunt, and that he had no case to answer in that trial. That position was vindicated by the erudite judgment of the Court of Appeal, which ruled that the trial court erred in calling upon the accused persons to mount their defense. When the then Attorney General, the Honourable Godfrey Yeboah-Dame, vowed to file an appeal and actually went ahead to do so, I took the view that it was done to save face and that there was no scintilla of merit to his appeal. Indeed, the appeal was, to say the least, grossly incompetent. My involvement in the case of Republic versus Ofosu-Ampofo and another is a matter of public record. At the initial stages of the trial, I was on record as counsel with the Venerable Tony Lita and my former boss, the Honourable Marietta Brew. It was our position as a team that the charges against the Honourable Ofosu-Ampofo were trumped-up charges and motivated purely by politics. I still stand by that view. Ethically, a prosecutor should and must have the courage of his convictions and must remain fearless to stand by those convictions even in the face of a severe storm of public criticism. Strident criticism should not be the reason why a self-respecting prosecutor must abandon his professional convictions in favor of political praise. So I am owning up, fellow citizens, to stand by the professional decision I took that in my current position as Attorney General and Minister of Justice, and for that matter, the prosecutor in those cases, I was not going to suddenly recant my professional position and continue to prosecute the accused persons in those two cases. No new evidence has been presented to me upon assumption of office as Attorney General to cause me to abandon my professional convictions. As an aside, in any decent constitutional democracy, the disgraceful and unethical conduct of the former Attorney General, the Honourable Godfrey Yeboah-Dame, in interfering with a key witness who also happened to be the second accused in the Atufosin case, should have resulted automatically in a mistrial. But let us leave that for another day. Ladies and gentlemen of the media, the second reason why I dropped the charges in some of the cases, as I stated above, is that the charges were defective and upon careful scrutiny were filed against the promptings of plain common sense. In the case of Republic versus Collins Dauda and others, for instance, the first accused was charged with misapplying public funds to the tune of 200 million United States of American dollars. In laying the charges, the prosecution failed and or neglected to take account of the basic fact that it was part of that 200 million US dollars that was used to construct the houses at Shagleme. In other words, the value of that built environment is, in my considered opinion, a key determinant of how much of the total sum was allegedly misapplied by the Honourable Collins Dauda. Discounting the value of the built environment renders those charges, in my considered opinion, defective. The prosecution in this case also failed and or neglected to take account of payments that were made by other ministers who took office after the Honourable Collins Dauda. For instance, the Honourable Atachia, as Minister of Works and Housing, approved a payment to the tune of 5 million United States of American dollars in 2017. That ought to have been considered in determining the value of state funds that the Honourable Collins Dauda had misapplied. But that wasn't done. And note ladies and gentlemen of the media, that the Honourable Atachia was never charged, even though the Honourable Collins Dauda was charged subsequent to the actions of the Honourable Atachia. So I leave that to your own considered judgment as to why that happened. Now, in criminal law, an accused is entitled to know with precision the crime that he has committed and the burden that he must discharge in order to prove his innocence. This is basic criminal jurisprudence, and the charges in this case, and the other in terms of the cases affecting the other accused persons, fail to meet the standard of precision required to put an accused person on notice of his criminal liability. Ladies and gentlemen, the third reason why I dropped the charges in some of the cases was that the evidence adduced so far fell significantly short of what was required to convict the accused persons, and yet the state pressed on with the prosecutions. I consider that to be a total waste of state resources. As noted by Promang JSC in Afoko and Attorney General, that is the case that I cited earlier, the prosecution may enter a nolle prosequi in situations where, upon review of the proceedings, the Attorney General detects fatal flaws in the case which may lead to the acquittal of an accused person. In other words, a nolle prosequi may be entered to avoid possible verdict against the prosecution. My review of some of the cases certainly revealed fatal flaws in the case of the prosecution. A few examples are in order. In two of the banking trials still ongoing, I took the decision to withdraw the charges against Mr. Johnson Pundit Asiama for the simple reason that in the course of my review of the cases, my attention was drawn to an internal memo prepared by the Prosecutions Division of our department for the attention of the former Attorney General, the Honourable Godfrey Adame, which recommended that the charges against him be dropped. This is very significant. This is an internal memo prepared by professional prosecutors advising the Attorney General that the charges against our current Bank of Ghana, the Governor of the Bank of Ghana, be dropped. Note that Mr. Johnson Pundit Asiama was charged with contravention of the Banking Act for granting a facility of 300 million cedis to Universal Merchant Bank and for causing financial loss to the state in the sum of 150 million Ghana cedis. The internal memo, which I just cited earlier, concluded as follows. This is very instructive. It says, a study of the facts of the case indicates that the initial facility of 300 million has been recovered, leaving 150 million outstanding. This office has confirmed from the Bank of Ghana, that is, the Attorney General's office has confirmed from the Bank of Ghana through Mr. Alexander Tarr, that is PW2, prosecution witness 2, that the interest from the outstanding amount is presently being serviced by UMB Bank. Mr. Tarr also indicated that UMB has an amount of 150 million locked up with CBG, that is Consolidated Bank Ghana. It is expected that when the said sum is released to UMB, the loan amount for which A3, that is Johnson Pundit Asiama, was charged with causing financial loss to the state will be repaid to the Bank of Ghana. This therefore may render the charges proffered against A3, that is Johnson Asiama, moot, leading to his discharge. So the professional opinion of the prosecution division was very, very clear that the charges against the current governor of the Bank of Ghana are unsustainable. In other words, factually, and then in terms of the evidence available, he could not be convicted of the offenses charged. Obviously, the former Attorney General failed to act on these recommendations which were made to him by the prosecution's division. If he disagreed with the recommendations, I am unable to say, but I agree with them. Based upon these recommendations, I dropped the charges against Johnson Pundit Asiama in both the Unibank and UT Bank cases. In coming to this decision, I am fortified by the rule contained in Rule 40, Sub-Rule 2, Clause A of the Legal Profession, Professional Conduct and Etiquette Rules 2020, that is LI 2423, which provides that in a criminal case, a prosecutor shall refrain from prosecuting a charge that the prosecutor knows is not supported by the facts. But note that I have not yet dropped the charges against the remaining accused persons because I am currently in discussions with the receivers in order to understand the financial implications of any decision I may take in the future. Ladies and gentlemen of the media, my third reason for dropping the charges was that in some of the cases, the evidence led so far showed that there was reasonable doubt as to the guilt of the accused persons. And as stated earlier, the ethics of the legal profession mandate that a prosecutor should not continue to pursue a case in the face of overwhelming doubt regarding the guilt of the accused. In other words, where a charge is not supported by the facts and evidence, a prosecutor is ethically enjoined to drop the charges. I'll give you an example. In the case of Republic versus Stephen Opuni and another, the entire case was built around the fact that an untested liquid fertilizer, Litovit, was purchased by Cocoa Board, and further that the fertilizer was not efficacious. In the event, according to the case of the state, all sums of money spent by Cocoa Board to purchase this fertilizer caused financial loss to the state. Rather strangely, not a single farmer was called by the prosecution to prove this fact. On the contrary, officials at Cocoa Board who were invited by the investigators gave statements to the effect that Litovit fertilizer was one of the most effective fertilizers purchased by Cocoa Board, and that the farmers preferred Litovit fertilizer to the granular fertilizer. More importantly, in the course of the investigations, Cocoa Board took statements from two farmers. Whilst one stated that he did not see any significant change on his farm, the second farmer stated that after using Litovit fertilizer, he saw a significant increase in yield, and that Litovit fertilizer is a very good fertilizer. Again, in the course of the trial, the defense tendered an official report from Cocoa Board which covered field visits by Cocoa Board officials. The report, which was tendered, was to the effect that Litovit fertilizer is a very good fertilizer and that farmers actually prefer it to other fertilizers and was the fertilizer of choice in areas in which Litovit fertilizer was supplied. This is clear evidence that contrary to the case of the prosecution, the use of Litovit fertilizer rather increased the yield. The farmers who used Litovit fertilizer, including the then national best farmer, in their evidence testified that Litovit fertilizer increased, the use of Litovit fertilizer increased their yield and that it was a good fertilizer. During the course of their investigations, the investigators had two reports from Ghana Standards Authority on Litovit fertilizer. The first report, which was later confirmed to have been done, and listen to this carefully, members of the press, to have been done at the Cosmetics Department of GSA, the department which does not have the mandate to test Litovit fertilizer, okay, indicated that the sample of Litovit fertilizer submitted for testing did not have any fertilizer ingredient in it. This finding was challenged by the accused persons and the investigators, together with representatives of Cocoa Board and the suppliers of Litovit fertilizer, took a second sample from the warehouse of Cocoa Board. This sample, which was again tested by the same Ghana Standards Authority, but this time by the proper department with the mandate to test fertilizers, concluded that the samples taken was fertilizer in the first place and that the fertilizer was efficacious. Furthermore, it is interesting to note that in this case, the complainant, that is Dr. Edu Ampoma, who was the third prosecuting witness, PW3, lied under oath to implicate the accused persons, for which reason a perjury application was filed by Dr. Stephen Opuni against him. The then trial judge, Justice Hoyenuga, for reasons which are totally unacceptable, did not hear the application, but rather stated that hearing the application will prejudice the hearing of the main case. He therefore adjourned the application until the conclusion of the case. This is most unacceptable because in a criminal trial, it is important to hold the scale of justice evenly, and any doubt raised must inure to the benefit of the accused persons. Ladies and gentlemen of the media, my fellow countrymen and women, the judiciary in our country is independent under the Constitution. In the context of criminal justice, judges demonstrate their independence by remaining neutral and impartial arbiters in disputes between the state and individual citizens. The scales of justice must be held in a delicate balance between the obligation of the state to prosecute crime and the right of the accused to a fair trial. Conduct by judges that undermines the fair trial rights of citizens should be concerning to a self-respecting prosecutor. Without meaning to impugn the integrity of any of the judges who were involved in the cases in respect of which I have either entered a nolle prosequi or withdrawn the charges, I am deeply concerned not only about the conduct of some of the judges, but also concerned about the fact that the executive branch took certain actions that could be reasonably interpreted as inducements to convict the accused persons. An ethical prosecutor must endeavor to protect the innocent and convict the guilty, and one cannot do so if the judiciary is not impartial. When Justice Hoyenuga single-handedly expunged otherwise exculpatory evidence from the record in the Opuni case, and then proceeded to rule that the accused had a case to answer in his ruling on submission of no case, he was far from portraying a semblance of neutrality. Indeed, he directly undermined the fair trial rights of the accused persons. Again, when in accordance with law and practice, Justice Anoche Jima decided that he was going to hold a de novo trial, that is a new trial, in the same Opuni case after when Hoyenuga went on retirement, the retirement of Hoyenuga. He was instantly transferred to Kumasi, and the case was allocated to a new judge, who then proceeded to adopt the proceedings and continued the prosecution. Also, the decision by the executive branch of government to promote some judges who were sitting on some of the cases is very concerning. The perception, whether true or not, is that the promotion may be an inducement to convict the accused persons. Ladies and gentlemen of the media, fellow countrymen and women, in conclusion, I wish to make it abundantly clear that I did not take these decisions lightly. As I indicated above, I consulted widely and reviewed the files diligently before coming to a decision on each of the cases. You will note that in some cases, such as the Snake case and the banking cases, I withdrew the charges against some of the accused persons, while others are still under consideration. I am keenly aware of the need to balance the public interest, in this case, against the interests and rights of the accused persons. Also, as Attorney General, I take absolute responsibility for all the decisions so far taken. I am not under any instructions or pressure to discontinue any case or to bring charges against anyone. Those who are in a haste to tag His Excellency the President of the Republic as a clearing agent should hasten slowly, because he is not responsible for prosecutions and has not directed me to drop any case. Moreover, with the exception of one charge of bribery in the Opuni matter, in respect of which, no evidence was laid, none of the persons affected by my decision so far has looted state resources. There is a gulf of difference between the offense of causing financial loss to the state or misapplication of state funds and the offenses of bribery, corruption, or that of using public office for private gain. In the latter offenses, the individual charged can be accurately labeled as looters. In the former, it will be thoroughly unfair and actually defamatory to label the accused persons who have, as people who have looted state resources. So I thank you very much. These are the reasons for my decisions, and I will now take questions if there are any. Thank you.
For more news, please visit our website graphic.com.gh or follow us on Facebook at Daily Graphic and on YouTube and Twitter at GraphicGH.
Subscribe now.